Death is unpredictable and leaves a trail of grief and despair. It can take a turn for the worse if the deceased died without authoring a will, or the deceased was secretive and did not disclose their properties to their kith and kin. Ailing patients who are arriving in their death throes may be too weak to coherently provide evidence about their assets, leaving families to struggle with paying hospital bills and the debts of the deceased. Is there a legal obligation for institutions or persons to reveal to families of the deceased information about property or funds on specific bank accounts? More specifically, in the case of secret bank accounts undeclared by the deceased, are financial institutions in breach of trust and their fiduciary duty to act in good faith towards their client if they do not disclose this information? How does the surviving spouse or beneficiaries of the estate of the deceased go about locating these unreported assets? How can those in the know about the secret bank accounts and other unreported assets be incentivized to reveal this information? Legal experts opine that a moral obligation exists, as well as the duty of care by the financial institutions to disclose to families the assets and funds that belonged to the deceased. Susan Nabate, a practicing family lawyer, cites her professional experience to reveal how widespread the practice of non-disclosure of assets among spouses is.
I think it's very common that you don't know your spouse's PIN for the ATM. You don't even know which bank they save in, or you don't even know how much they have. It stretches through all accounts we have, and if it's NSSF, we don't know this information, especially in marriage. And I think I would rate it at 80%.
Notwithstanding the lack of trust that motivates much of the secrecy between spouses, there is typically more diligence about disclosure of joint property rather than the property owned by individual spouses.
As long as they have the joint property, that's called the family property, they don't care about the others. And most times it's done now of protection, of probably, they say probably the country has gone sour, that my spouse could do something or kill me to take this or steal from me.
In practice, Nabate reveals that it is typically women who are the most secretive about the property they own.
We've had these issues at FIDA Uganda, not only with men, but also women, and I think they are the biggest percentage that spouses don't know about their property, their wealth.
Biggest issue could be that most of them are in cohabiting relationships, and yet there is no law protecting this kind of relationship, unlike for marriage. So many of them don't have any protection measures, and as such choose not to disclose just in case the relationship goes sour. This stems from past experiences where women have been thrown out of their homes after many years with their partners. This usually arises when the deceased elects to conceal their properties, including bank accounts, land titles, and houses, amongst others. As a consequence, legally recognized survivors are unable to exercise their right to benefit from the hidden assets as beneficiaries and trustees of the deceased's estate. In the case of undisclosed bank accounts belonging to the deceased, the likelihood is that they remain unclaimed, which Section 119 of the Financial Institutions Act of 2004 defines as wherever any current or savings account has not been operated for a period of 2 years, or time deposit account has not been operated for a period of 2 years after the date of maturity of the deposit. Nellie Ellengot, who heads compliance at the Bankers Association of Uganda, reveals what happens to the money on such accounts.
After a period of 10 years, that money will be transferred to the central bank. But before that, we have an obligation after 2 years to notify the customer that the account is on what we call a dormant account. So after 2 years of no credit or debit activity from a customer, that account is transferred to a dormant account ledger. And after 3 years of that transfer, we are supposed to publish these accounts in the print media. So I'm sure you have seen several banks publishing a list of customers whose accounts have since become dormant.
This may be helpful if the holder of the bank account is alive. In case of sudden death, there are fears that unscrupulous employees of financial institutions could deliberately steal the funds of the deceased who did not disclose the funds to their families. Do individuals or employees in the bank have a moral obligation to disclose to the relatives the details of the properties and funds that belong to the deceased? A lawyer I spoke to revealed that it may be possible to inquire informally with staff in the bank who one believes may know and can help locate the hidden accounts of the deceased.
Sometimes we also advise people to make wills. Make a will. Make a will, even if you're young. Like, you see, it is not that when you make a will, you're dying tomorrow. It's a protection measure.
In the wake of one's demise, a will, which is the testamentary disposition of the deceased, typically provides an account of the inventory of the estate of the deceased. It gives the beneficiaries and trustees of the deceased a legal obligation to claim the estate and properties of the deceased through an executor or executrix. When a person dies having left a will, the person is said to have died testate, and the property of the deceased is disclosed in the will. In the event the person died without leaving a will, the Administrator General, as required by Section 17 of the Administrator General's Act, makes an inventory of the estate and keeps its account under interstate succession. Section 201 of the Succession Act provides that when the deceased has died without leaving a will, those connected with the deceased either by marriage or by virtue of being lineal kin, such as children, grandchildren, parents, and grandparents, are entitled to obtain letters of administration of the estate of the deceased. Only after obtaining this legal authorization can an inquiry into the estate begin. In the case of the inquiries about possible unreported bank accounts belonging to the deceased, for example, Nelly Alengot lays down the procedure.
The nature of the contractual relationship between the bank and the customer and the confidentiality and trust aspect, we would not release information directly to them without having the legal paperwork. So we would advise them first to have the necessary documents. Like I said, it would be first maybe a court order to inspect the bank book records to see whether an account is held. And once that is established, then they should have the right, again, documents like either a letter of probate or a letter of administration that now can give them authority to access the funds of the deceased.
However, in the event the deceased did not leave a will and did not provide the disclosure of their properties, including funds, the survivors can only rely on goodwill to locate the assets. It is what Susan Nabate describes as a fishing expedition.
We look at normal family property. It's not the residential home, but it's something, property that you have bought. We believe that maybe over these years he has done that. If it's a government worker, he has some pension, gratuity waiting for him, yes? Even in companies these days, in organizations, we have saving schemes. Did you know that? Saving schemes. So all these things you might not know.
This uncertainty is what underscores the need to draft wills, as Nabate argues.
It's not an announcer of death, yes, as people call it. No, it is something that you're putting information, not that you're putting the titles beneath the will, yes? Just putting information that this and this is here, this and this goes here, this and this is here, so that you make it easier for people to manage your estate.
Some of the properties belonging to the deceased may have been acquired through proceeds of crime, such as money laundering. Information on hidden assets of the deceased can be filed by lawyers in the course of their practice, wary of sanctions if found complicit in illicit activities such as money laundering and facilitating their clients to fraudulently conceal assets. This often motivates lawyers to be whistleblowers.
I definitely have no right to withhold that property, and someone can actually sue me if I do that, because that would, it's even against our code of conduct as lawyers, because we are officers of court and we have to enforce justice in all ways.
Tax advisors, who are typically accountants, risk sanctions if found complicit in facilitating their clients to conceal assets that deprive the government of much-needed income tax revenue in doing so. As such, it is prudent for tax advisors to counsel their clients to disclose their assets and file honest and accurate tax returns.
There are already sanctions in the law that put an advisor in trouble if they are complicit in defrauding the government out of tax.
Perhaps there are progressive lessons that financial institutions could replicate from institutions such as NSSF that provide an instant message on individual savings. In case of sudden death, families may rely on this electronic message as evidence to support their claims. Ultimately, it is advisable to make a will containing an inventory of one's assets and liabilities, and with instructions on how these will be discharged upon one's demise. A will prevents one's estate from going to waste upon one's demise to the detriment of your